Today we're going to talk about power of attorney, intervention orders and guardianship. These three documents empower an individual to act on behalf of the person they care for, be it their mum, dad, wife, brother, sister, child. Power of attorney is for the grantor, or the person who is looking for support, is deemed to have capacity to sign the document themselves saying that they would like Jean or Joe Bloggs to be their power of attorney, and that's okay. Intervention order is when the person or individual does not have any capacity. The court would have to appoint somebody through an intervention order to act on their behalf for that one-off thing. If it's for ongoing issues, then you would go down the guardianship route, where again, under the Absolute Capacity Act, you are granted guardianship by the courts to look after the individual's affairs. Again, financial and welfare. Firstly, we'll cover the power of attorney document. The first part being financial, or what's referred to as continuing power of attorney. And basically that's to deal with money, property and finances. The second part is welfare, which is to deal with health and social care services. To empower you to make decisions on behalf of the person you care for. For power of attorney purposes, these two aspects can also be combined. So you're not just doing it for one part, you're doing it for both parts. So it's like a combined power of attorney. With power of attorney itself, the person you care for, or who's the grantor of the power of attorney, can still have capacity. Because they can sign the form themselves, they can still make some informed decisions for themselves. However, with all power of attorney documents, you must have an incapacity statement. The next form we're looking at is the intervention order, where basically an individual has to intercede on behalf of the person who lacks capacity, i.e. does not have the capacity to make their own decisions regarding their own welfare or property or their own finances. Now what can happen there is a court can grant this to an individual or a group of individuals to make the decision on behalf of the person for that one aspect of their life. If they need a lot of support for an ongoing period, then we're really looking at guardianship. Because guardianship is basically in dealing with, again, financial and welfare aspects, or a combination of both, which with guardianship it generally is. This should be considered if you have a child who's severely disabled and mentally impaired, who's turning 16, 3 months before they turn 16, you should be applying for guardianship. Because if you're dealing with social work, that's the first thing they will ask. Also, guardianship, it can happen at any time. People having a stroke, a brain injury, where they can't really deal with their own affairs, then somebody must be there to intercede on their behalf. And again, that can be family member, or members, it can be social care themselves, or always a responsible person. And ultimately it's up to the court to decide in that case who they deem a responsible person, and there's no objections to this. Please always look at the Office of Public Guardian website. They have all the information, all the forms, all the list of fees, etc. and they're best placed to give you the advice and information support regarding this.